Hello, my name is Alex Stewart, and in this video resume I will demonstrate just why I am perfect for the role of legal officer within this international organisation. My key concern as a legal officer will be to provide a First Nations voice enshrined in the Australian Constitution, a concept that will appease the office of the UN High Commissioner for Human Rights and State Sovereignty. Aboriginal and Torres Strait Islander people have struggled to obtain a voice in this country for centuries, and only in recent years have they finally been able to take something akin to a stance against policies and regulations that have consistently sidelined them. Australia still isn't operating perfectly in regards to its population of First People, and this stems from what is still a severe lack of representation in the political space. Through establishing a First Nations voice that will be enshrined in the Constitution, the human rights of the Aboriginal and Torres Strait Islander people will be promoted and protected, as has been mandated through the General Assembly. It is vital to state that the current position of establishing such a voice is rather negative, with the government not believing in such an addition to our national representative institutions as being desirable or capable of winning acceptance in a referendum. It has been stated as not providing equal civic rights to all citizens, as the democracy of Australia has been built on, and that such an additional representative assembly comprised only of Indigenous Australians is inconsistent with this fundamental principle. It is critical that the government see this as necessary in regards to basic equality and human rights, so that the Constitution can be amended accordingly. My resume will demonstrate just how this stance can be altered to allow for such an important change. Our Constitution immediately reflects the importance of the separation of powers in the government, with the first three chapters being dedicated to the Parliament, Executive and Judicature respectively. The legislative power of the Parliament is outlined in Part 1, Section 1 of the chapter, stating that the Queen, a Senate and a House of Representatives comprise the Federal Parliament, and it is the power of the Commonwealth that is vested in them. Similarly, the executive power of the Commonwealth is vested in the elements comprising the executive government, and the judicial power is vested in the Federal Supreme Court, which is identified as the Judicature. It is this concept of the separation of powers which plays a considerable role in ensuring that the passing of new laws is fair and that each one is addressed accordingly. In examining whether or not a new law can be passed, Sections 51, 61 and 71 of the three chapters, respectively, must be examined in order to determine whether or not the law is appropriate for the specified power. The Parliament has the power to make laws for the peace, order and good government of the Commonwealth with respect to various factors, such as trade and commerce with other countries, postal, telegraphic, telephonic and other like services, quarantine, census and statistics, among others. Section 61 extends to the power of the executive government and allows the Governor-General as the Queen's representative to ensure the execution and maintenance of the Constitution and of the laws of the Commonwealth. Section 71 also extends to the previously mentioned power of the Judicature and determines whether or not laws can be passed under the federal jurisdiction. In determining whether or not it is capable to enshrine a First Nations voice under the Constitution, these sections need to be utilised. Under Section 51(26), it is established that the Parliament can make special laws for people of any race for whom it is deemed necessary to have such laws. With the lack of representation consistently being voiced by Indigenous Australians, establishing such a voice could certainly be viewed as a necessary special law. Through the executive power, the law could be deemed as one of the Commonwealth and would need to be executed and maintained. Finally, the establishment of a High Court of Australia under Section 71 was deemed to be necessary for laws such as this one, which would require such a supreme jurisdiction. And using the two-step process behind establishing Commonwealth laws and the constitutional validity, the power and prohibitions as to power must be inquired into. This process was particularly focused upon in the authority of the Grain Pool case. A head of power was established in Section 51(26), so the question is whether or not this power has any prohibitions regarding establishing a specific voice for Indigenous people. While this decision would be put before the Judicature, there is a high capability of such a voice being enshrined. Human rights are a key concern in this occupation, and enshrining a First Nations voice in the Constitution is primarily focused on advancing those rights for a consistently underrepresented group of people. After the deletion of Section 127 from the Constitution in the 1967 referendum, Indigenous people finally began to see improvements in regards to their basic human rights. In 2012, a report asked for an expert panel on constitutional recognition of Indigenous Australians be established, and in 2015, it was recommended that a joint select committee for CRATSIP be created. These ideas are precursors to this proposal and serve as previous examples of how the rights of Indigenous people have improved in recent years. The Racial Discrimination Act 1975 was referenced in the Kuwata case as being a form of legislation that directly prohibits discrimination, providing basic human rights to people of all races through treating them equally. It was argued from the point of this legislation that Section 5126 is therefore a contradiction of this Act, as it appears to discriminate through providing special laws for people of a particular race. However, while this dissenting verdict was provided, Section 5126 cannot be seen as discriminatory, as it simply serves to provide certain races with rights that would not necessarily give them an advantage, but greater representation and general human rights. From this conclusion, we can determine if the idea of a First Nations voice is consistent with equal civil rights. In enshrining a First Nations voice into the Constitution, one of the major concerns has related to whether or not it will still allow for equal civil rights amongst people of all races. The 2017 National Constitutional Convention, or the Uluru Statement of the Heart, is what seeks this constitutional reform, with their reasoning being to empower Aboriginal and Torres Strait Islander people to take a rightful place in our own country. This goal is important, as it is reflective of a consistent issue in this country. Despite the fact that Indigenous people now have equal civil rights, they still do not have an influential political stance. The aim of this First Nations voice is to ensure that the issues and concerns of Indigenous people are voiced on a notable national level. Through having a constitutionally enshrined voice for people of this race, extensive progress can be made in regards to addressing issues in Indigenous communities. Such a position would be a desirable goal, as it would eliminate continuous discussion in regards to Australia's treatment of Indigenous citizens, or at least go some way towards stifling these arguments. Furthermore, it is in line with the aims of the OHCHRSR through promoting the ideals and rights of this race of people. In regards to a First Nations voice being consistent with equal civil rights, it would surely pass judgment. This is due to the fact that it is a special law designed to cater to a consistently marginalised community who requires such a form of representation, to ensure that their rights remain protected and equal. In fact, the lack of Indigenous representation currently present in the Parliament could be argued as a form of inequality, considering this race of people are recognisable as the first citizens of this country. With this reform both a possibility and a desirable idea, it is pertinent that the government take steps to amend the Constitution for the purpose of the establishment of a First Nations voice. The amendment will need to be conducted through a referendum, which the government has indicated as not being a current possibility due to the belief that such a reform is not capable or desirable of winning acceptance. This can be rebutted on the basis that Aboriginals have seen previous success in gaining rights through referendums. The consistent discussion surrounding the place of Indigenous people in the government is indicative of Australia as a whole having opinions in regards to the necessity of representation. All amendments to the Constitution do require a referendum that is compulsory to vote in, so it is only appropriate that the government attempt to amend the Constitution by providing a First Nations voice. The population of Australia is entitled to voice their opinion rather than have the government voice it for them. While the process of amendment ensures that enshrining a First Nations voice in the Constitution is not a certainty, even if proposed by Parliament, it is at the very least worth a referendum to see how greater representation of Indigenous people is viewed. Therefore, I propose that this idea be brought before the Australian Government if I am successful in applying for this job as a legal officer. Thank you for your consideration.